All right, I think we're going to go ahead and get started. Good afternoon, everybody. Thank you for joining us today. First and foremost, I hope that everyone is staying healthy and safe, and hopefully we can do these presentations in person soon. Thankfully, we're lucky to stay connected on Zoom, so we really appreciate everyone tuning in today. My name is Brittany Atkinson, and I'm here today with my colleagues, Kevin Riefenstahl and Colin Davis. We are attorneys at Chartwell Law, and we practice workers' compensation defense in New Jersey exclusively. Between the three of us, we handle about 6 different venues in New Jersey. So we have a great range of experience with the different judges throughout New Jersey. In New Jersey, the judges are all so different. And per the statute, they're given a lot of discretion. So it's very helpful to get to know your judge and get to know your venue. One thing that's different from other states and that we really get to benefit from as being defense attorneys in New Jersey is that each defense firm gets assigned one judge in each venue. So for example, all of our cases in Bridgeton are assigned to Judge Marchand, and every 3 weeks our cases appear on what we call our list. So for continuity purposes, we assign one attorney to each venue. That attorney becomes familiar with the judge and the different attorneys in that particular venue, which really helps with settling cases later on and really moving the cases as quickly as possible. So if you ever refer a case over to me or to Colin and say we flip it over to Kevin, it's because Kevin is the handling attorney for that venue, and he knows the judge the best, and he knows the other attorneys the best, and he really knows how to most efficiently move the case as quickly as possible. The purpose of today's program is to really give you an overview of the practice of New Jersey workers' compensation. So whether you are completely new to New Jersey or you're here for a refresher course, we're going to try and keep it relatively simple so that we can really cover as much as possible within the hour. If you would like to dive deeper into any of the topics that we touch on today, please do not hesitate to contact us directly. Our contact information is on the website. Kevin was also gracious enough to prepare a PowerPoint today, which will also be posted on the website. So please feel free to access that and refer back to it whenever necessary. There is a Q&A box that we're going to use today. So throughout the presentation, if you have any questions, type them into that Q&A box. We're going to try to steer away from the chat box and the raise hand option, only because we can monitor the Q&A box a little bit better so we can go back to the questions if we need to. So with that said, I'm going to turn it over to Kevin to get us started.
Thank you, Brittany. So as Brittany said, my name is Kevin Riefenstahl, and I'm going to start off with a brief history of workers' compensation. Let me share my screen here. There we go. So does anyone know who this is? I can't see anybody, but this is Blackbeard. You may have heard of him. He's a very famous, very notorious pirate who is also widely credited with creating one of the first workers' compensation systems ever. If you were a crew on Blackbeard's boat and you happened to get injured, he had a schedule of disabilities, much like Pennsylvania. For example, if you lost your right arm, you would get 600 pieces of 8. Now, you got to bear in mind that this was late 1600s, early 1700s. So a piece of 8 was worth about 12 cents, or is worth about 12 cents now. So in today's dollars, a piece of 8 would be about 5% or 16 and a half weeks, according to the New Jersey schedule. And in addition to that, 500 pieces for the left, which is interesting to me that a left arm is considered less than a right arm. 500 pieces of 8 for the right leg, and also less for the left leg. In addition to the compensation, you are also allowed to remain on the crew. Now, here's the thing, though. In the late 1600s and the early 1700s, the trick was, if you got hurt, to survive your injuries to be able to get these rates. So that's just a really brief, I think, fascinating history of the beginning of workers' compensation. And with that, I will turn it over to Colin to start talking about the 3 remedies that are available in New Jersey.
Hello, everyone. My name is Colin Davis. As you've heard, I'm going to talk you through the 3 remedies in New Jersey workers' compensation. The three remedies are medical benefits, temporary disability benefits, and permanency disability. The medical benefits are, as you would think, any type of medical treatment, a doctor's appointment, physical therapy, diagnostic studies, surgeries, anything that fits in the medical field. Temporary disability benefits are when someone is someone is entitled to temporary disability benefits when they have been out of work related to the work injury for 7 days. On that 7th day, temporary disability kicks in, and petitioners are entitled to that when a petitioner or a doctor takes a petitioner out of work or places them on a work restriction that the employer cannot accommodate, such as an example would be you're a package handler at, say, FedEx, and you work on the floor lifting items up to 50 pounds. If you have a work restriction by the doctor saying no lifting over 10 pounds, it's likely that it won't be able to be accommodated, so you would then likely be entitled to temporary disability. Temporary disability benefits also are paid at 70% of your average weekly wage. So if a petitioner's average weekly wage was $1,000, their temporary disability rate would be $700. Which is important that we are able to find out petitioners' wages as early as possible so that we can make sure the temp rate is correct, as well as making sure that we don't have to possibly deal with reconstruction of temporary disability, which we can touch on later in this seminar. Then the last benefit is permanency disability benefits. Unlike the first two benefits, which you are entitled to regardless of filing a claim petition, the only way to obtain permanency disability benefits is by filing a claim petition. If you do not file a claim petition, then you will not be entitled to permanency disability benefits. Therefore, if someone files a claim petition, it can be pretty much guaranteed that they will be seeking some form of permanency. Within those three remedies in comp, there are two classifications of injuries. There's a traumatic injury, whether it be physical or psychological. These claims occur during the course and scope of work, and you have to determine whether this arises out of work, such as if say you were, as I mentioned before, a package handler, and you're, say, lifting a heavy box and you feel a twinge in your back, that would be a traumatic accident. Or you're a delivery driver and potentially you slip on some ice. That will also be considered a traumatic accident. The other type of accident in workers' compensation is occupational claims. Occupational claims are typically more chronic injuries or conditions that result due to a particular trade, occupation, or process in the employment, and they have contributed to, and the work has been the major contributor to the disease. The type of occupational claims that we traditionally see are, as you can see in the slide, carpal tunnel when not caused by trauma, asbestos, chronic bronchitis, other lung disorders, cancer claims, sick building claims, allergy claims, lead, and stress claims. And more recently, it is likely that we'll start seeing COVID claims under the occupational standard as well. Again, the occupational claim, it differs from the traumatic accident in that typically with the traumatic accident, you have 2 years to file your claim petition from the date of that accident. Occupational claims, you have 2 years to file your claim petition within knowledge or knowing that the work you perform has helped cause that injury. As you can see from the next slide, there's a nice, funny little joke. And further, with typically with workers' comp, the traumatic claim is the one you see more often. I would just loosely say it's probably about 85 to 90% of the claims that we have. However, of late, I have noticed a slight uptick in occupational claims. Typically, you see those from people who have worked at jobs for extended periods of time, such as mechanics, any type of construction worker doing heavy lifting for an extended period of time, and those typically fall into the occupational claims. I will now hand it back over to Brittany to touch on additional onto coverages.
Actually, I think I'll take it, Colin. It's jurisdiction
Okay.
now.
Oh, it's my apologies.
Oh, I'm sorry. No. Oops. Nope. So, what is going on here? So there are three ways of establishing jurisdiction in New Jersey. One is the contract of hire was in New Jersey, if the accident occurred in New Jersey, or there is a substantial amount of employment for the employer in New Jersey. We see a lot of that with, for example, truck drivers whose routes go through New Jersey. Living in New Jersey, if you're a New Jersey resident and your accident happens out of state, just because you live in New Jersey is not necessarily enough to establish jurisdiction in New Jersey. And then there's a concept down there called no double dipping. What that means, and we see it a lot in New Jersey, given our neighboring states of Pennsylvania and New York, where a person who lives in Pennsylvania was hurt in New Jersey, there might be dual jurisdiction, but there's no double dipping. What that means is that you can't get the same type of benefit from both states. So for example, in New Jersey, permanency is different than wage loss that you might be able to get in Pennsylvania. Colin, you want to talk about some additional defenses?
Yes, the additional defenses when it comes to workers' compensation claims, one of the most obvious to look for is the statute of limitations. As I briefly mentioned before, the statute of limitations in workers' compensation is 2 years from the date of the accident as it relates to traumatic claims. As it relates to occupational claims, it must be filed within 2 years of the date at which the claimant first knew the nature of the disability is related to his or her employment. Another defense is notice. When it comes to traumatic claims, notice occurs within 90 days of the accident under NJSA 35:15-17. As it relates to occupational claims, there is no real notice requirement. As I mentioned before, it's when the petitioner first knew their disability was related to its work employment, as this could come a few years after when they had been working, and depending on the injury, such as a construction worker, it may take 5 to 6 years, maybe even 10. We see some going all the way up to 15, 20 years of employment. The third is the going and coming rule from work, which also includes routine travel to and from work. However, in most cases, routine travel to and from work is not compensable. However, there are some exceptions. Typically, when you are injured, you're injured within the course and scope of your work on the employer's premises or at a premises that becomes the area that is controlled by your work. Typically, some parking lots have this. This is where this issue may come into effect. The park, if someone falls on ice in a parking lot, there can be some contention as to whether the employer controls that parking lot, or if it's just a public parking lot that they have no control. If the employer controls the parking lot, it's likely that will be deemed a compensable accident. If the employer has no real control of the parking lot, they do not dictate where the employees are to park, then it is likely going to be considered routine travel to and from work. However, there are exceptions within that we can see. I have seen judges in New Jersey occasionally find compensable, but that happens on a much smaller basis. I will now hand it over to Brittany to talk about medical treatment.
Kev, I backtrack about who is covered.
Oh, okay. Sorry.
Yeah, and I just wanted to add one thing too about the going and coming rule. I mean, if the employer is directing them, so you say, you know, all the guys that are working for a particular employer are meeting at a shop, and then they're sent off to do to a job site. That travel may be found compensable, and that's one of the exceptions within the going and coming rule. So you want to really evaluate the cases on a case by case basis. But I'm going to get into who is covered. And I mean, obviously, employees are covered, and the employee is defined specifically in the statute as someone who performs services for an employer for financial consideration. The statute goes on to exclude certain workers. Independent contractors are one of these workers that are excluded specifically in the statute. And typically we think of an independent contractor who's working for a company as really a non-employee. I see this a lot with truck drivers. They own their own trucks. They're contracted with a business. They're labeled in that contract as an independent contractor. They're paid on a 1099. While the independent contractor defense really it remains a viable defense, the case law has sort of made it impossible for the employer to prove that someone is actually an independent contractor and not an employee for workers' compensation purposes. What they did was really come up with two tests. And if you fit within one of these two tests, then the court is likely going to find that you are entitled to workers' compensation benefits. The two tests, and I won't get into them into too much detail, but it's basically the control test, which really refers to whether or not the employer is directing or controlling what you're doing in order to get the work done. The second test is the relative nature of the work test. And that's really looking at whether or not the worker is economically dependent on the employer. And again, the example with the truck drivers is a lot of these truck drivers run exclusively for one business. And because they're running exclusively for one business and not really dabbling into running for any other businesses, the court's going to find that they are an employee for purposes of comp because they are economically dependent on that employer. I've even seen it where, like I've just mentioned, the contract specifically labels them an independent contractor, and the court will not even hold them to that language if they do satisfy one of these two tests. The statute also excludes casual employees, and here they're really looking at whether the employment is regular, periodic, or recurring. If it's not, it could be considered casual, and therefore they're not covered under workers' compensation. An example would be someone who did one or two side jobs for a business. Perhaps somebody came out as a handyman to fix a roof in a business. Sometimes these injuries can actually be covered under homeowners policy as opposed to a workers' compensation policy. So we would want to look into that if the facts came up. Sole proprietors are not covered. Volunteers are also not covered. Again, you're looking for that, services in exchange for financial consideration, which doesn't, occur with a volunteer. There are some exceptions that are listed in section 43 of the statute that you'd have to pay attention to. Elected and appointed officials are covered by workers' compensation. Board of Education members are covered. Volunteer firefighters, first aid or rescue workers are covered, and then reserve or auxiliary police officers are also covered. Another important aspect to consider is illegal aliens, and the case law has made it very, very clear that illegal alien status does not negate the protections of the workers' compensation statute. So as long as they can satisfy the other prongs of an employee, the fact that they are illegal will not keep them from getting workers' compensation benefits. So, Kevin, I think we are at
now medical treatment.
Medical treatment, yes. I'm going to cover medical treatment, and in fact, it sort of leads into my favorite topics that I've done other webinars on and other blog posts regarding medical provider claims. So But first, let me touch on medical treatment. Respondent is responsible for medical treatment that is reasonably necessary to cure and relieve the effects of the work injury. One of the biggest distinctions from other states is that the respondent gets to control and direct the treatment in New Jersey. So what does that mean? Petitioner is obligated to request authorized medical treatment from the respondent. The respondent then has the right to pick the doctor, schedule the exam dates, schedule the physical therapy, and even communicate with any of those doctors. The petitioner is obligated to comply with that course of treatment. And if the petitioner does not comply with that course of treatment, then the respondent is not responsible for those bills. If petitioner goes off and treats on his own. At the same time, if the respondent delays or refuses medical treatment, now the petitioner has the choice to go out and treat on his own. And at that point, he can seek unauthorized treatment and will likely come back and seek reimbursement for those bills from the respondent. Depending on the circumstances of the specific case, we would have to argue whether or not the respondent would be responsible to cover those bills. Sometimes this often results in health insurance liens and could make things a little bit messy. Once treatment commences, respondent has a duty to authorize all curative treatment until the petitioner has reached maximum medical improvement. And so we're looking for that MMI opinion. In other states, I understand that the carrier will go off and get an IME, an independent medical examination, to address MMI status, return to work status. In New Jersey, we're looking for the treating doctor to address MMI. Once we get that MMI opinion, then the respondent has no more obligation to continue treating the petitioner. We're often asked whether the respondent has to provide palliative treatment. And more often than not, we see the word palliative and we immediately think, okay, no longer curative, let's cut off treatment. We're done. We're not responsible for this anymore. Just know that there is case law out there that says sometimes palliative treatment is compensable medical treatment and therefore the responsibility of the respondent. If the palliative treatment, and you would get these words from the treating doctor, but if the palliative treatment is helping the petitioner function in his daily life, then it's likely going to be found compensable and therefore the responsibility of the respondent. So it is rare to see that, but just know that that case law is out there. So when you see that word palliative, don't just automatically think, I'm safe, I can cut off the benefits, I'm no longer responsible. What constitutes medical treatment? It's very liberal. It could be anywhere from physical therapy to having to build an addition on someone's home. There is a case out there, the SWIO case, and basically the respondent is responsible for providing every piece of equipment necessary for a paraplegic to comfortably live in his home. And in that case, it involved building an addition, building ramps, wheelchairs, everything. So it could be significant. It could be as simple as PT or even chiropractic visits. Medical billing, Kev, if you want to click to the next slide. Medical billing in New Jersey. So this has become sort of a hot topic, but basically the statute and case law provides that the respondent must pay for medical bills pursuant to what is usual, customary, and reasonable. And I'm going to refer these to the Ucr rates. That's what we call them. It's just easier to say than usual, customary, and reasonable. But basically, they want us to look at what other providers are charging and billing and being reimbursed for by other carriers for certain services in the same geographical area. There's no fee schedule. It's kind of up in the air. So when we get these medical provider claims in, we get a packet of exemplars of bills, and we're basically comparing what other carriers are reimbursing providers for the same services. If the provider is not happy with their payment, they have recourse. I just mentioned medical provider claims. They can file a medical provider claim before the workers' compensation court. It's their own recourse. Excuse me. It's filed separate and apart from the claim petition. They can also file a motion to intervene in the workers' compensation case. More often than not, we do see the medical provider claims. rather than the motion to intervene. The motion to intervene has the ability to hold up the underlying claim petition and getting that case settled. So we do see them more in the medical provider claim. Medical provider claims, and I'm sure anyone who's practicing or handling New Jersey at this time knows that there has been a significant influx in the past 5 years or so. We're seeing them filed now for physical therapy. When medical provider claims started being filed, we were seeing them, they were looking for, $20,000 to $30,000 more of a payment. Now we're seeing them where they're filing a list of, 10 different physical therapy sessions, and they're seeking, $20 here, $30 here. So they have increased litigation costs. They have become a huge flood in the courts, but nevertheless, they are there, and we are finding ways to continue disputing them and defending them. One of the biggest issues right now with medical provider claims is the ones that are related to out-of-state injuries. So for example, we see a New York claimant that has no connection whatsoever to New Jersey, but maybe that New York claimant came over and had surgery one day in New Jersey with a New Jersey doctor. The carrier gets the bill, it's adjusted per New York because that's where the claim is established. And from what I understand, New York reimbursement rates are very similar to Medicare, so they're fairly low. So the provider then files in New Jersey and they seek more money per the UCR rates. And again, there's no set standard for what is UCR, so it's very negotiable. There has been some favorable case law that recently came down, which helps eliminate some of this litigation, but there's also still a lot of claims out there. They're continuing to file. There's certain medical provider firms that's solely what they do. So I mean, I could spend a whole hour just talking about this alone, and I won't get into too much more detail on it, but if you do have any other questions or want to discuss it further, please do not hesitate to contact me directly. I'm more than happy to discuss. So I'll stop talking about medical provider claims, Kev.
That leads to me to go over temporary disability benefits. But as Colin said, there are 3 types of benefits in New Jersey workers' comp. There's medical treatment, temporary disability benefits, and permanency benefits. Temporary disability benefits and medical treatment can run concurrently. Otherwise, it's mostly a sequential process. You can't get permanency benefits until your medical treatment is done, i.e. placed at MMI, and once you're at MMI, your temporary disability benefits can stop. Temporary disability benefits are based on your weekly gross wages or the average 26-week period prior to the work injury. That would include overtime, bonuses, tips. It's your whole total compensation package. It's your gross pay that is used to calculate the average weekly wage. Compensation is based at 70% of that average weekly wage. It's 70% because temporary disability benefits, as well as permanency benefits, are tax-free. And they are subject to minimums and maximums that change every year based on the average wage for the state of New Jersey. I don't recollect what the mins and maxes are for 2021. Payment of benefits, there's a 7-day waiting period. You have to be out of work for 7 days. Once you get to that 7th day, you are entitled to temporary disability benefits, which are retroactive back to the first day that you were out. You cannot collect temporary disability benefits for more than 400 weeks. And there's the big problem issue in New Jersey is partial temporary disability benefits. That happens, for example, when the petitioner is given work restrictions that can be accommodated, but at a lower rate of pay than they were making before. The statute doesn't really address that, but it's become practice that the injured worker will collect his pay and then the respondent will pay additional temporary disability benefits up to the 70% of what the petitioner's average weekly wage would be to make them whole. The reason why it's not in the statute and there's no case law on this is, frankly, no one wants to make bad law and get stuck having to do it or having not to do it. So it's just become sort of the custom that partial temporary disability benefits are paid. Plus, as Brittany alluded to earlier, we're in front of the same judge every 3 weeks, and it's sort of good litigation practice to do that so that the judge doesn't get annoyed that you're not doing it. Temporary disability benefits stop on a return to work or MMI. There are other situations where temporary disability benefits may stop. There's a case law called Temecki where a worker got hurt, was collecting temporary disability benefits, and then opted to go to college full time. In that case, the court held that the petitioner/student was not entitled to temporary disability benefits. The other time when temporary disability benefits can stop is when the injured worker is released by a physician to return to work, light duty, and a job is offered. If no light duty is available, then the temporary disability benefit has to continue. However, if there is light duty and it is offered, but the injured worker refuses to take the light duty, then no temporary disability benefits will become due. Now, after temporary disability benefits comes permanency benefits, and Colin can address that.
As I had mentioned previously, when going over the 3 remedies you're entitled to with workers' compensation in New Jersey, permanency disability benefits you have no right to them unless you file a claim petition. A claim petition is required to obtain permanency disability benefits in New Jersey. Within those disability benefits, there's a schedule of disabilities that for each year. There's one from 2021, 2020, 2019, so on backwards, and a new one comes out each year. There's typically a slight increase in the monetary numbers each year with the new percentages. As it relates to the schedule of disabilities, the hand, and this is a bit of a misnomer because the hand is not just your hand. In workers' compensation in New Jersey, the hand is from the tip of the finger to the bottom of the elbow. So anything from below your elbow to the fingertips will be considered the hand in New Jersey. The arm in New Jersey is from the elbow to the shoulder. The same goes for the foot. The foot is anything below the knee. So from the tip of the toe to right below the knee. So a broken ankle, that would be a foot. A broken fibula, likely going to be a foot injury. And when it comes to the leg is from the hip to the knee. The knee typically starts with the meniscus tear, an ACL tear, an MCL tear. Those would be the knee. However, that's considered the leg in New Jersey's workers' compensation. There are also body parts that don't fit directly into the schedule of disabilities. They fall into what is considered partial total. That is the shoulder, the back, the hips. And when it's settling on a partial total matter, those monetary numbers and weeks are higher. Most recently in New Jersey, there's been a slight change to the permanency disability benefits when it comes to the hand and the foot. There's a new hand and foot bill in New Jersey that has increased the number of weeks for both the hand and the foot. And the number of weeks jump at change from below 25% of this 25% disability rating. So for the hand, previously below 25% of the hand, it was 2.3 weeks for every point of disability. Now with the new bill, it's 2.5 weeks. And when the settlement is 25% and higher, the weeks used to be 2.65 per percentage point, have now raised to 2.85 weeks per percentage point. As it relates to the foot, the old numbers were 2.5 weeks per percentage point, have now increased to, I believe it is 2.65. And 25% and over for the foot, the weeks were 2.85 weeks per disability point, are now 3 weeks per disability percentage point. This has caused a bit of an issue with some of the judges, as well as calculations can differentiate between both parties, petitioner and respondent. However, it's starting, as cases are coming and judges are becoming more familiar, the calculations are improving. We do have something, and some of you may have heard, we reference what is called Ucr, that takes the schedule of disabilities, and you can input your direct numbers, and it will give you out the weeks along with the payment per week for the total gross settlement number. Now, as I said, there's the new hand and foot bill. For 2020 and 2021, Ucr will calculate that for us directly. Unfortunately, we do have to do the math on the cases prior to 2020, which has caused some new changes as well. The new hand and foot bill, as it relates to permanency, only pertains to cases that are not reopeners. If the case is a reopener, the new hand and foot bill does not apply. However, a memorandum came down from the director that it is retroactive. So say we have an active open claim from 2018. It never settled. Now, because of the new hand and foot bill, these new week numbers apply. The other thing to note about the chart or Ucr is when we hit the 30% partial total or 180 weeks, once we get over that number, there is a significant increase in the monetary amounts. Specifically for 2020, the chart at 30% is $56,934. And when we go up to just 1 percentage point higher at 31%, the gross total jumps almost $20,000 to $84,072. There is another slight bump at when we get to the 42.5 percentile in as well. The other thing that comes into effect with permanency in New Jersey is we have multiple body parts sometimes. Say somebody was in a car accident. They injured a foot and an arm. And to get that, what happens there is, while they're rising out of the same accident, this is what we would call stacking on the claim. It doesn't add percentages together, but it adds additional weeks and typically pushes it to a partial total value. So just an example, if say petitioner has a left hand injury and a left leg injury, we're going to settle on 15% of the left hand and 15% of the left leg. We put that in the Ucr, that's equivalent to 14.37% of partial total, or $22,252. It doesn't add up to 30%, which is why there's the conversion to 14.37%. It's a funky number, but that's how we avoid adding percentages, but merely adding weeks to such as. However, in the case of partial total, if it was 15% of the cervical spine and there was also a shoulder injury, it would be 15% of partial total as well. So you would add those percentages in that to be 30% of partial total. I understand that can be a little confusing. However, if you have any additional questions on that, and typically this is a case-by-case basis, we can address them directly. You can give us a phone call or email after, and I can further explain any of that as well. The other thing that comes along with permanent disability is the possibility of a credit. The type of credit you get for permanency is an Abdullah credit, which entitles the respondent to a credit for prior work or non-related work disability in a percentage paid at the rate in effect when the claimant receives the current award. specifically, say someone has a neck injury, and we know in 2000, they say they have a neck injury in 2021, but we know they had a neck injury in 2018. Say they had a laminectomy. Typically, laminectomies settle anywhere in the range of 20% to 27.5%, depending on the judge in New Jersey. I know it's a wide range, and we can explain that shortly as well. But we would be able to obtain a credit for that prior injury. The easiest way to be able to obtain a credit is to be able to obtain the medical records, so we can determine exactly what happens. Sometimes we'll have an ISO search and it'll say petitioner injured his neck. If we can't show exactly what that injury was, or at least get some medical records documenting what the injury was, it'll be hard to argue for a credit with the judge. But if we can specifically show an MRI, any type of positive diagnostic study to the same body part of our new injury, we have a stronger chance to be successful in obtaining a credit. I'll now hand it back to Brittany to go over permanent total disability.
So before I get into permanent total disability, we did get 2 questions about where to find the Ucr calculator. It is really helpful. I just posted the link in the Q&A box. I don't know how many people can see that, but I just wanted to quickly tell you how to access it. If you go to the Department of Labor and Workforce Development website, there's actually a link to the Ucr calculation off to the right-hand side. You click on that, and that'll actually take you into the Ucr calculation. And you would, in order to click for your partial total award or calculate your partial total award, there's a couple tabs at the top. Click on partial total, and it'll take you right to that calculator. Permanent total disability. These are much more far and few than the cases that we settle for partial disability, because basically the employee is saying that they're no longer able to work. If they are no longer able to work, they're likely going to file for permanent and total disability. It doesn't necessarily mean that they're bedridden or they're paralyzed. It just means that they have been rendered unemployable. And we'll see it a lot with people who apply for Social Security disability benefits during the course of the claim. If a petitioner is found to be permanently and totally disabled, they are entitled to 70% of their weekly earnings for a period of 450 weeks. The weekly rate is subject to the minimum and maximums for that year. Once that 450 weeks is up, the petitioner is subject to an examination to address his continued permanent and total status. If the petitioner is found to be permanently and totally disabled as a result of both, say, a work accident and pre-existing conditions, whether they've had prior workers' compensation awards or prior unrelated work accidents, then it may be beneficial or even possible to share liability with the second injury fund. And that really opens up a whole other can of worms, which again can be a topic in and of itself. Let's see here. What's next, Kev?
Claim petitions, litigation procedures.
Okay.
So we told you earlier that the temporary disability benefits and medical benefits are provided just by virtue of getting hurt and or not being able to work. A claim petition has to be filed for an injured worker to obtain permanency benefits. A claim petition generally has to be filed within 2 years of the accident or last compensation payment. So say, for example, someone gets hurt on January 1st of 2020, and they received 8 months of treatment, say until August 15th of 2020. The 2-year statute of limitation does not go from the accident date. It goes from the 8 months later, the August date. So it would be August 15th of 2022 would be when they would be out of time to file their claim petition. It's nice that's the way it's supposed to work, but it's sort of workers' compensation in New Jersey is considered remedial social legislation. So frequently judges will bend over backwards to save a claim petition. It can be anything, what big fights fall over what is considered medical treatment, so forth and so on. Another way that the statute of limitations is told for filing a claim petition is if someone is deemed to be insane, that will toll the period of time that they have to file a claim petition until such time as they are no longer considered insane, I think is what the statute calls it. Once the claim petition is filed, the respondent has 30 days to file an answer from the date of service of the claim petition, except for good cause. If an answer is not filed, the judge may, on motion by petitioner's counsel, either suppress defenses or permit filing of answer on fixed terms. So that's why it's important that if you receive a claim petition in your office, that you forward it to your defense counsel as soon as possible. I see questions up here. Do we want to get to these questions before we move on?
Yes, Kev. I was actually typing an answer to one of the questions. What if an injured worker is released to return to work but removes him or herself from the workforce due to retirement? Can we stop TTD? So one of the things that I like, all the clients to remember when dealing with these cases is that workers' compensation in New Jersey is not job protection. You have no duty to get them back to their pre-injury job following their course of medical treatment. So once you get that MMI opinion and or that return to or release to return to work, you are no longer responsible for temporary disability benefits. Kev or Colin, do you have a different take on that?
Nope.
Yeah, so it doesn't matter if that person leaves for retirement or if they leave for a different reason, you're not responsible for getting them back to work, which I know is a little bit different than in some other states.
The way I like to think of temporary disability benefits is really essentially wage replacement. If they retire, then they no longer have any wages that require replacement. That's.
Mm-hmm.
And to Kev's point, the same can be said about a petitioner just quitting work as well. There's no longer wages to be replaced. So if they quit, we would also argue we can stop temporary disability.
There's one more question, Kev. I'm just going to real quick. For occupational injuries, is quote unquote should have known also considered as an alternative to quote unquote first knew of the nature of disability?
I would argue that it would depend on your judge and the case specifically. Based on the statute, I would have to say no. However, say petitioner, this happens a lot with they will have like chiropractic treatment, which we don't normally authorize in New Jersey, but they'll have had chiropractic treatment for years due to a lower back injury. And then all of a sudden we will have a claim petition for an occupational exposure for a lower back injury. I would absolutely argue with the judge that petitioner should have known that they were getting this chiropractic treatment, while not the strongest medical treatment, was likely due to the type of job they had. Now that's job specific. That would be specific to a certain job. Now, if they're getting chiropractic treatment maybe once a year, that would be different. But if they're going on a regular basis, or the other thing would be, say they had just a randomly had an MRI in the past and it showed bulges or herniations, and they went to the doctor, knew they existed, they weren't related to work because they didn't have a claim, they didn't know about it. We could also argue that might have been knowledge as well, but this is typically a case specific and an argument we have to make and convince the judge rather than it being an actual direct comparison to first knew and should have known.
Great, thank you, Colin. So next, after the claim petition is filed, the petitioner's got medical treatment, he's paid their temporary disability benefits. We move to resolving the case. And most compensable claims are resolved under what we call an order approving settlement. It's provided for in section 22 of the statute. It's based on the schedule of disabilities that Colin touched on earlier. The tricky thing with the order approving settlement is the accrual of benefits. Colin told you that each injury percentage-wise converts to weeks. Well, getting back to what we explained earlier, how the benefits run sequentially, your permanency benefits start to run as soon as your temporary disability benefits are done. The case might not be over. You still might have to, there might still be investigation. Both sides have to get expert exams and stuff. So once the case is settled, the accrual period is then, it sort of becomes the lump sum that is payable right at settlement. And then depending on the length of the petitioner's total awards, the award accrues on a weekly basis until it is fully accrued and fully paid. Also, under an order approving settlement, an employee can reopen his or her claim within 2 years of the last payment. It's that payment thing that raises its head again. It's not from the 2 years of the date of the award, it's 2 years from date of last payment. Frequently, I like to say that petitioners almost always will reopen if their first award is under an order approving settlement. But they have a burden of proof. They have to prove that the disability has subsequently and materially increased. And then the other type of order or the other type of settlement is called a Section 20 settlement, and Colin has that.
Now, the Section 20 settlement is quite different than the order approving settlement. A Section 20 settlement is a full and final settlement in which it also results in a dismissal. Petitioner does not have any reopener rights. There are typically 4 reasons permitted for Section 20 settlements. There's an issue of jurisdiction, an issue of liability, an issue of causal relationship, and an issue of dependency. The easiest 2 ways to look at it without going into those are the 2 would be a denied claim, or if the permanency doctor found a 0% disability. However, within that 0% disability, I appear in front of a judge who will accept Section 20s very easily. As long as both parties are in agreement, she will put the Section 20 through. However, there are 2 judges in in New Jersey that is not the case. They have much higher standards for Section 20s, even though we have a 0. So in that case, some of those judges won't even allow a Section 20, even if there's 0 permanent disability found by our doctor, if there's, say, a positive finding on an MRI, or some even will cause a hiccup due to some physical therapy. The other thing to note about Section 20 settlements are they typically come with a premium, which the judges require. Each judge, the premium is different, and depending on the type of injury or treatment provided, such as, say, surgery was recommended, the petitioner chose not to proceed with surgery, and then we obtained a permanency exam and got a 0% disability. We'd be able to Section 20 that in certain venues, such as one I appear in, because there was that recommendation for surgery, the judge is not going to base his Section 20 recommendation or allow a settlement for a lower number. Say, just because he didn't go through with the surgery, you might think you could get it done for $10,000 to $15,000, but the judge is going to take into consideration that surgery being recommended, knowing petitioner, if they went through with it, would likely settle on an order approving settlement. So the premium would be significantly higher. So an example would be a petitioner gets treatment, surgery is recommended on the shoulder, and he chooses not to go through with that. Now, if he did go through with the shoulder surgery, you're sitting in the 25% of partial total realm. And just to give you an idea of where that falls, let me put it in Oscar real quick and give you the exact number so I can show you how we go about converting it into into a Section 20 number. So most judges anymore fall in the range of 25 to 27.5% on most shoulder surgeries. Obviously, this is case specific, but in 2021, 27.5% of partial total is $50,000. So if we have a case where surgery is recommended but declined by petitioner and we're able to Section 20 it, the judge is going to set that number in the $50,000 range to Section 20, and he's going to put the future surgery and likelihood of petitioner's ability, if they were able to settle an order approving settlement, at a much more higher dollar value. Whereas if we had the same shoulder injury but surgery is never recommended, we're going to possibly be able to settle in the 17.5% range for a Section 20, and that falls in about the $28,000 range. So we would look to settle that for, say, $25,000. Yes, as I mentioned, that's a little less than when I said premium, but because it's conservative treatment, sometimes we can get a little bit, do it a little bit lesser. However, the premium, it varies by judges. Some it's $5,000, and some judges will make it incredibly high because they really just don't want you to settle Section 20. The one last thing on Section 20 settlements is Section 40 lien rights. Whereas on an order approving settlement, Section 40 lien rights entitle us to recoup 2/3 of any third-party settlement. And when it comes to a Section 20 settlement, the settlement monies are not lienable. However, the money paid for medical treatment and temporary disability are still lienable under Section 40 lien rights. So we will be able to recoup some even on a Section 20 settlement, even though the actual settlement is not lienable. I will hand it back over now to Brittany to handle costs and fees.
Sure. So I just want to touch on costs and fees really quickly because we're almost running out of time, and we have some really great questions that I'd love to get to. So we just went through the two types of settlements. There's the order approving settlement under Section 22 that comes with reopener rates, and then a Section 20 settlement that we refer to that closes the case out permanently. It's a full and final settlement. Under what we refer to as the OAS settlement, that's the Section 22 settlement. Fees are going to be split between the respondent and the petitioner. So the 20% counsel fee, respondent will pay 60% of that. The other 40% will come from the petitioner share of the award. We will split the cost of petitioner's permanency exam report fee, which is usually about $600, so $300 payable by respondent, $300 payable by petitioner. The respondent is always responsible for the stenographer fee, which at this time is $75. Section 20 settlement, the petitioner pays for all the fees except for the stenographer fee. So that 20% counsel fee is coming right out of the petitioner's share of the award. Respondent's not responsible for any of it. Permanency exam report fee coming right out petitioner's share of the award. Respondent is not paying for that either. So you will get an order, you will see it, and we will walk you through how to pay it, but it's pretty easy to follow once you learn how to read it, who pays what. I just wanted to, we're at 1 o'clock now, but there was one really great question. What is the obligation when an injured worker moves out of state and continues to request or need treatment? I don't know if you guys want to touch on this, but we always have the ability to get them back to New Jersey for an exam, you know, the big ones, the need for treatment exams, the permanency exams. But if it's just the regular course of treatment that's now been recommended on an otherwise compensable case, there's case law out there that actually says the respondent is responsible for setting up treatment out of state. And again, you can get them to come back for that, you know, the big exam with a New Jersey doctor so that we can, you know, ask questions, MMI status, work status, and all this stuff. But you are required to provide treatment out of state. Do you guys have anything else to add to that?
No, that's yeah. I mean, treatment is, the statute requires that the petitioner submit to a doctor licensed in New Jersey at the request of respondent for exams. It doesn't really touch on treatment. So if the petitioner wants to move out of state and is actively treating, a judge will order the treatment be set up. However, when it comes time to settle the case, the petitioner is going to have to go back to New Jersey for a permanency exam.
Yeah, and we really want to get them back here so that we can talk to doctors who are familiar with New Jersey workers' comp system and really will give us what we need. I'll hit one more question, even though I'm 1 minute over. If the injured worker returns to work on the 8th day, do we pay temp for 7 days? So the answer to that is then you would start paying, correct, you would pay temp for
They'd be entitled to 1 week of temporary disability.
Would be entitled to 1 week. I think we are out of time. We covered a great amount of New Jersey comp, so I'm sure there are more questions. There are more questions we didn't get to. I'd like to see if I can go about answering those after the program.
There was one, Britt. Someone asked if the PowerPoint will be available. We can absolutely make the PowerPoint available to anyone who would like a copy.
Yeah, so I actually did respond. I typed an answer to that. Everything will be available on our website. I don't think it's available right now, but once we conclude today, I think both the PowerPoint and a recording of the webinar today will be uploaded. So that
everyone that signed up will be emailed a copy of the recording, including the PowerPoint.
Oh, great. Great. All right. Well, everybody have a great week and thank you for joining us. If you ever think of a topic or that you want us to explore, let us know. We are more than happy to put together additional webinars in the future. We like staying connected with you as much as possible. So please reach out and let us know. And yeah, that's all I got. You guys good? Anything else?
Thanks for tuning in, everybody.
That's all I have. Thank you. And if you have any questions, feel free to contact us directly.
Yes.